So, esteemed participants, our topic is contemporary criminal policy with respect to economic crimes, national and international mechanisms. And I'm glad to welcome our speakers. Thank you for coming. Many of you came from far away. You came and you devoted your time to visit our panel. I thank the participants who joined us to hold a discussion. I suggest that we conduct a lively discussion within 2 hours, a professional discussion. I suggest that speakers take up to 10 minutes to leave time for questions and answers and opinions. If you do not mind, I shall ask leading questions before your presentation so that you could reflect, also give the answer to my question, the questions that might have arisen in the process of discussion, and the answers we would like to get from you as a competent source. Then, when the people from the floor join in, they can ask questions and express their opinions. And I would like them not to take up more than 3 minutes in their interventions. And then at the end, I will ask you not to leave. We shall make a picture of everybody to put on record. Probably we shall start making changes in the contemporary criminal policy. Let me introduce the speakers. Konstantin Klinovsky, Chief Advisor, the Criminal Justice of Constitutional Court of the Russian Federation, Ms. Lolita Rinch, Federal Prosecutor in Eastern District in New York, Natalia Shatikhina, Chair of Criminal Law at St. Petersburg University, the lawyer, Managing Partner of CLC Company, Dr. Guy Rodkov, Director General at the Ministry of Justice in Israel, Thomas Firestone, Permanent Representative on Legal Issues at the Ministry of Justice of Russia, Andrei Porfiryev, Chief Lawyer of Advocates Lawyer Afanasyev and Partners, Yuri Batuk, a partner in Pinsent Masons, our colleagues from Great Britain, and Simon Davenport will join us later, a royal lawyer, also from Great Britain. So there's the composition of our panel. If there are no objections, let us start our roundtable discussion. It's very important that we decided to discuss this issue from international viewpoints, listening to opinions of experts who are respected not only in their own countries but internationally. In this sense, we can make a brainstorm to start developing new approaches, or we might come up with some proposals that could be used in our country. So the contemporary criminal policy in the economic sphere is a very dynamic direction of public relationships, one of the most dynamic. Any lawyer understands that one of the main things is borrowing or borrowing from norms of other countries. And modernization of criminal law has a lot of such borrowings. Russian legislation has been changing significantly recently. Here you see on your screens, you can see the slides in the booklets as well. Here you see the statistics of changes in criminal legislation in the recent years. Mostly it was targeted to make the criminal law more humanistic. As for the number of amendments and changes, We never had so many changes before. I'm one of the stubborn people who believes that economic crimes should be punished in the economic way. If there is no threat to people's life and health, if there are only economic implications, they can be rectified with economic punishment. Why shouldn't it be over cruel in punishing people? I'm sure you will share my opinion. The major important thing is irreversibility of the punishment rather than the cruelty of punishment, because those people are not murderers and not terrorists. Certainly there should be a balance. So we mostly alleviated our criminal legislation, but there were cases when under some circumstances we had to tighten to make the legislation more severe, and there should be a balance in criminal policy. One of the new criminal norms adopted last year is for creating a sham company, one-night companies. We introduced criminal liability that allows us to combat corruption, because such one-night companies will cash money which are used for bribes. I think we're conducting a balanced policy, alleviating petty crimes, or implement criminal norms when the situation requires it. On the whole, the trend in the Russian Federation is to have lower rate of economic crimes. Here you see this slide showing changes in the situation. Starting from 2007, you see a decline in economic crime. So, not to take the words out of our speaker's mouth, I give the floor to Konstantin Kalinovsky, who will tell us in more detail about the changes in procedural novellas undertaken recently, and then we shall discuss the changes which are still going on in our country. Konstantin, you're welcome. Thank you. First, I would like to thank the organizers for the possibility to speak to such a respectful meeting, which is number one in the country. As for the problem, the slide does not show fully the materials. Starting from 2003, we observe serious changes in Russian legislation in criminal policy towards liberalization. Some crimes were decriminalized. The floor of sanctions went down for some crimes. That was the first wave. Now we are living through the second wave. That entails a lot of work requiring radical transformation of people's ideas and consciousness. There is the common liberalization trend, not only in economic crimes, but there is the overall trend, because the previous legislation was very repressive. Starting from 1997, if a person steals a $3 worth a crime, stealing, he gets $3. A second time it's 10 years. So if a person stole $10, he gets as much as 10 years. And the prisons were overcrowded with people sitting for such minor crimes. I also would like to, about decriminalization of commodity smuggling. It used to be a crime if a lot of commodities were transported through the boundary without recording it. If it's not narcotics or drugs, it has become sort of decriminalized. There are some other acts, specific acts, when the legislation regulates certain specific issues. One shouldn't forget, unfortunately, I'm not here representatives of enforcement bodies. from Russia, the prosecutors, the investigative committee, or the police. There's a lot of criticism of such liberalization. First of all, coming from criminologists working on crime prevention, from scientists working in institutions of higher learning of the enforcement system. There's a lot of displeasure from the judicial system. Now, half the cases in courts are the cases to review earlier decisions related to decriminalization. Half the cases are real criminals, and half the cases the people who are serving a sentence, but their sentence has to be reviewed. So you see the statistics. There is the overall decline of economic crimes and crime as a whole. But there is experts' opinion that certain categories of economic crimes are growing, like raiders activities. So experts estimate that it has increased hundreds of times. Some experts call it hidden crime, which is not officially registered. So the growth is 100-fold. Some scientists believe, and they enjoy public support and support from political forces. There are a lot of poor people in Russia who do not like rich people, and many of them are displeased with liberalization of criminal legislation. I would like to support this idea and express one idea which deserves attention. Here we should look at the procedural component. Criminal policy is not only substantial law but procedural law, how criminal laws are applied. If it is poorly applied, businessmen will be put into jail for drugs, for instance. Well, sometimes some crimes involve the enforcement bodies. Some people from the enforcement bodies, judges, they have an interest in business. And they use legal mechanisms in criminal purposes. Therefore, corruption is very much related to such issues. Now let's look at the amendment in the Code of Criminal Procedures. The trend is common, like pre-justice. There were amendments into the law. The criminal court cannot but take into account the decision of the civil court. There used to be a practice, for instance, the person is charged with tax evasion. There are certain tax arrears. A criminal case is opened. It is challenged in the civil law. The taxes have been improperly calculated, and they won the case, and there is no arrears. But the criminal case goes on, and the investigator says, "Oh, well, we don't care about the decision of the civil court." At first glance, it is not related to economic crime, but it is related. Now, amendments to put in custody such a category of criminals, it's very difficult to implement. Article 140 of the Code of Criminal Procedures. One can't initiate a criminal case on tax issues without instruction from the tax authorities, for instance. Again, about tax crimes. Some cases are turned over into the investigative committee, so the jurisdiction of criminal cases have been changed, and some of the people left the system. The trend is to limit, to restrain the enforcement system. We even have the expression not to kill the businesses. So the major potential in developing criminal policy is does not lie in the substantive law, but in the procedural law. The judicial system should become independent. One should overcome corruption in the enforcement system. And the major resource here is in providing real protection of business, because business votes with their feet. They don't care about laws. Capital is just flowing into a more favorable place. Therefore, the objective of criminal policy is not just to change the criminal laws, but to fight for proper law enforcement. Thank you, Konstantin. So everything you said is true. We feel the same way. I would add that we had to make amendments into Article 108 of Criminal Code, which bans the arrest of businessmen before court. This measure of restraint as keeping in custody cannot be applied to businessmen now. Well, if a person was in hiding, if it has no permanent residence, then it can be applied. The situation has improved over the last months. If you look at the statistics from 2009, 265 people were arrested before court. After those amendments, the number of people arrested dropped 16%. So it dropped to 220,000, and in 2011 there was another decline of 7%, and now only 200,000 are arrested before court. Mostly they are businessmen, entrepreneurs. They used to be arrested in 90% of cases. Now they account for only 40 or 45%. It's not certainly good, but it's better when all businessmen were arrested and kept in the remand center.
Последствием его бизнес захватывался, ну либо просто он.
But so long as the business was taken over, we had to resort to such unprecedented measures in order to improve the situation. So the application of law, which Konstantin was referring to, is in the practices that we have to change them using legislative norms, and so that the result could be there, and some results have been achieved. We have been looking at the statistics in the U.S., so we borrowed from the site of the state of Montana to observe the trends in that state, and at the slide you can see that whatever you have in front of you on the table, you can have a look at that. If you look at the lower portion of this table, you can see that in the past, beginning from 1990 up to 1990, if you look per 100,000 residents, the number of crimes sort of became smaller, from 12 million to 9.5 million. But if you look at the upper diagram, you can see that the number of major scams and with the federal authorities and they are investigating into those scams and financial machinations, and it was quite surprising for us too. But meantime, it's also a trend that we have to pay attention to. Before I give an opportunity to explain the situation and to explain to us what is happening in the U.S. and to give the floor, I would like to say that the royal lawyer Simon Davenport has joined us from a different sort of club, and it's very nice to have joined us, and it's very nice. So now, Lara Klitsch, I want to ask you to express your position with regard to the trends that prevail, Lord Lynch, in the economic crimes which are going on in the U.S., how much it complies to what you have in reality.
You've asked me to comment somewhat on the trends, I think focusing on the nature of my practice, which is in the federal courts, where we see the increase in the economic crime. You're referring to the top part of the chart. I think that is explained by a number of cultural factors that are occurring in the U.S., but one of them is, in particular, what I would refer to as an increase in the size of the victim class for economic crimes. The perceptions of who are the victims of crimes are, in fact, a big driver for enforcement in the U.S., as well as they play a factor in the types of sentences that are received and how those sentences are structured. And what has occurred over time in the United States is the nature of economic crime, at least in the federal courts, has shifted from one person defrauding another to classes of people losing large amounts of money. And the classic examples that most recently received a great deal of publicity, some 10 years ago, the Enron collapse generated a great deal of publicity both in the U.S. and outside the U.S. And approximately 5 years ago, between 3 and 5 years ago, the collapse of the American capital markets and real estate markets have generated a great deal of publicity and a great deal of public outrage. And when we see the collapse of large institutions that held resources and funds for a wide class of people, you see the rise in the victim class, and so greater attention tends to be paid to economic crimes. At the same time, you will see, because of this public outrage, often a great call for greater punishment, going in somewhat the opposite direction that Russia has been going in. And certainly in the last several years, there have been a number of commentators, both political as well as journalists, who have asked the question as to why more individuals responsible for the financial collapse of the past 3 and 5 years have not been prosecuted and why they have not been incarcerated. But I think that in particular illustrates the similarity between the points that you were making, Mr. Moderator, and the conditions in the U.S., because as we review the most recent financial collapse, and as we review the cause of the losses that people suffered, both in terms of capital as well as in terms of the value of investments, particularly real estate, what we often see is not so much criminal activity as with the mens rea, or the criminal intent that we find with someone who sets out to unlawfully take someone else's money. But we see a compilation of bad business practices, of negligent business practices, and of poor judgment that is often the realm of our civil courts, where, of course, the issues are trying to find out the culpable party and then valuing the loss and providing compensation. But it is very much human nature to want to put a face to the perpetrators of any crisis or fraud. And I think that the strength of any system is resisting that to the degree that you can set forth the principles on which you will engage in prosecution of individuals or corporations for economic crimes, and then sticking or maintaining with those principles over time, even in the face of situations where, again, there is a great public outcry. Now, that is not to say that we have not prosecuted individuals for their individual roles in the financial collapse, either of a specific institution or of a specific fund. And if, in fact, we can ascertain that individuals were committing fraud, that is to say, making false statements, essentially providing false information to people, genuinely seeking to defraud them, we will prosecute them, and we do prosecute them. But I think the important thing is, as you outline your economic crimes program, to focus on what is the biggest threat that you face and what is the best way to deal with that threat. And in the U.S., one of the other changes that we have seen has been in the growth of corporate criminal liability. You mentioned that sometimes there is a debate within Russia as to whether or not the company itself should be prosecuted. This is still a matter of debate in the U.S. Under our law, corporations are not persons. They do not enjoy the same constitutional rights as individuals, but they can incur criminal liability. Through a corporate action, great harm can be done, as we all know. So the issue has developed as to when do you hold the entire company liable for the actions of its officers, its directors, its supervisors. And under our laws, someone who has the ability to bind the corporation in a contract can also act in a way to convey criminal liability for that contract upon the corporation. When that happens, we in the Department of Justice are often faced with a number of conflicting agendas. And I will refer back to the scandal I mentioned earlier of the Enron Corporation. The Enron Corporation was a large corporation, mostly in the state of Texas, but they operated in the western part of our U.S., and they were engaged in what clearly was both negligent behavior and criminally fraudulent behavior. They essentially made false statements to their investors, their employees, their customers. They knew those statements were false. They knew people were acting on reliance in them. So they were committing criminal fraud. They also had as their accounting firm the Arthur Andersen firm, and there were numerous allegations as to whether or not the accountants for Enron knew of the criminal nature of the company's activities, because if they knew of the criminal nature of the company's activities and yet still provided documentation indicating that those activities were appropriate under accounting laws, the accounting firm could also be liable for committing that crime. And what happens there, and as was widely reported, was that the U.S. government sought to reach a resolution with the accounting firm whereby the accounting firm would admit their culpability but essentially agree to a series of reforms. This is called a deferred prosecution in our system. It means that I, the prosecutor, have the legal ability to prosecute you, but I will defer, I will hold off if in fact you agree to a series of reforms that will include compensation for victims, that will include reforms that are forward, that go forward in time, and that will also give me the opportunity to monitor your progress, either with someone that works in your company reporting to me, or the company reporting to me separately, or to a court. And if in fact the company essentially maintains its obligations for a period of time, usually 2 years, sometimes 3 or 4, I will then not prosecute the company. The benefit to this, to a company, is huge. It's tremendous. And in fact, this resolution is often sought by corporations in the U.S. Because if I bring the criminal charge against the company, if I bring the indictment against the company, I go into the grand jury, I present evidence of a crime, and I bring an indictment against the company, often the company has to go out of business. And so, of course, the larger result is that the hundreds of employees of a company who may not have been involved in criminal activity will suffer. Even if the company does not go out of business, many times they are prohibited by our laws from doing business with certain government entities. Certainly our military will not do business with companies that have been indicted or who have pled guilty or been convicted of a felony charge. But they will do business with companies who have admitted criminal conduct but obtained the deferred prosecution and made promises to improve their system. So we have a lot of competing considerations there. And what we've done in the Department of Justice is develop a system whereby before a corporation is prosecuted, before the company itself is charged, there are a series of considerations that I, as the chief prosecutor, have to ensure are considered. I have to look at the nature of the crime. I have to look at how pervasive it is. Does it involve 1 or 2 employees who bind the company, or does it involve the leadership of the company? Does it involve the CEO or the CFO, or does it in fact involve the board of directors, which of course is a much more serious concern and means that the criminal activity may be more a part of corporate culture as opposed to one person acting outside of corporate culture. I have to look at whether or not filing charges is in the best interest of the victims. Can the victims be made whole with financial compensation? Is the nature of the crime, have they suffered so much, however, that a criminal indictment should be appropriate? I have to look at the consequences to the other employees of the corporation. When I weigh possibly putting the company out of business or making it impossible for them to do their core business, is that punishment more severe than the activity calls for? So these are a series of considerations that have been developed as policy statements by the Department of Justice. They do not have the force of law. That is to say, a corporate defendant does not have the ability to go into court and make a motion before the judge to force me to consider those options. But within my system, as part of my ethical obligations within the Department of Justice, I am obligated to consider those factors. And we have found them to be very useful as we consider how to resolve corporate criminal liability. Because over time, a body of practice builds up, and you can compare and contrast how different companies have been treated over time. And you can compare and contrast under what circumstances a company will be indicted and under what circumstances a company may not be indicted. This is very helpful to private lawyers who represent the corporations. And in fact, they spend a great deal of time collecting data on when we choose to charge a corporation and when we do not choose to charge a corporation. I can tell you that most recently in my office, we decided we had a case that involved a very egregious violation of the Foreign Corrupt Practices Act. There's been a lot of discussion over that topic in the course of the forum, so I won't go into that statute again. Obviously, it involves foreign bribery. But we had an American working in China who was involved in a long-standing, widespread bribery scheme involving Chinese officials. And because he was a high-ranking officer within his company, his actions absolutely subjected his company, it was a bank, to corporate criminal liability. The company, having looked at the way the Department of Justice managed these situations, decided that they would, when they learned of this matter before we did, they decided to report it themselves to the Department of Justice. They did their own investigation and turned over the results of that investigation to us. They also showed us how over the years they had put in practice systems designed to prevent foreign bribery. They had provided training. They had a compliance program. They had, in fact, required all of their employees, including the one involved in criminal behavior, to go through this compliance program. So it was made clear to us that the company had done all that it could do to prevent this activity, but the individual chose to act nonetheless. After a great deal of discussion, ultimately, my office, in conjunction with the Department of Justice in Washington, decided to prosecute the individual for foreign bribery, and he recently pled guilty, but we chose not to prosecute the company. And we have distributed the press release and the documents about that case, and it has been our goal to provide guidance to the business community as to when corporate liability will attach and when we will choose not to. We try and make clear that these are the standards that a company must adhere to avoid the criminal aspect. Now, because we have chosen not to prosecute that company criminally, it does not protect them from a civil lawsuit from either the victim of the financial results of that criminal activity or someone else. And so they still will be held to account if, in fact, someone chooses to bring a civil lawsuit. So I think that the issues that you're talking about are very interesting ones. And the goal that we have in the Department of Justice is to try and ensure consistency and also to try and ensure transparency so that the business community and the legal community understand when they will be subject to penalties and when they will not be subject to penalties. Because of that, again, one other thing that we rely very heavily on is the sentencing guidelines structure. The sentencing guidelines in the U.S. have been a project that's now about 20 years old, but the Sentencing Commission undertook a study of all criminal statutes in the federal system and assigned a value to them of generally the general level of prison time that should occur if someone is convicted of this, and then if they take into account things such as the criminal background, if the person has more than one conviction, or if the person cooperated with the government and sought to help out instead of hide their crime. And these are flexible. Under our law, they're no longer binding on the court, but they're instructive. And the goal was to try and have, throughout the United States, in the federal system, some sort of consistency in the sentences that would be imposed. For financial crimes, a great deal of the sentencing structure involves the amount of money that's lost. And there you will see, in fact, the large sentences come into play under the U.S. system. It used to be that the sentences for white-collar crime were fairly low, although they did exist. We also have several different types of prisons, and so someone convicted of an economic crime did not go to the same type of prison as someone convicted of a crime of violence, particularly murder. And in fact, as the sentencing guidelines have evolved, as I mentioned, the more money involved in a criminal transaction, the higher the sentence can be. This has led to a great deal of discussion as to whether or not that should be the case, because in fact, you could have two people do the same act, but receive very, very different sentences based upon the amount of money that was involved in the crime. And so far, the amount of money still remains a very important element in this, and we've seen some fairly high sentences imposed in the last several years because of that. And that may lead to modifications in our sentencing guidelines. It's really too early to tell at this point. But there is, I think, in response to your questions, within the U.S. system, the desire for transparency, for clear sets of policies as to when and where we will prosecute a corporation, and also for consistency, both in how companies are prosecuted and in how companies and individuals are sentenced.
Спасибо, госпожа прокурор. Скажите, пожалуйста, я вас правильно...
Thank you, Mr. Prosecutor. Did I understand you correctly that you think it impossible to prosecute company criminally in full? Sometimes it is even harmful. Am I correct? To criminally prosecute a company.
It's never impossible. If in fact I can prove that someone who acted on behalf of the company committed a criminal act to benefit the company. If in fact, it happens a lot in the case where, as I mentioned, this individual was a very high-ranking banking official, was bribing Chinese officials to benefit himself, and it did benefit the company in some ways. I could have in fact charged the company as well, because the company was a beneficiary of his criminal actions. He was high-ranking. Therefore, his knowledge is imputed to the company. And the point I want to stress is that before I decide whether or not to criminally charge the company, I have to consider whether or not the harm that will occur because of that outweighs the benefits to society of charging the company. And there are times when I have in fact directed that a company be prosecuted, and there are times when I have in fact directed that the company itself not be prosecuted, but that the individual actors be prosecuted instead.
Спасибо. Ну, на самом деле, вот...
Thank you. You said that the size of the damage affects the punishment. Our approach is the same. The consequences, the damage, the loss involved in crime should be taken into account when sentencing, which is logical. We touched upon some Russian trends. Now we spoke about the United States, about the criminal policy. Now I would like to ask Dr. Guy Rotkov, tell us what is happening in Israel. Because Israel had, as a young state, could borrow the best practices from other countries. Probably your situation is more contemporary, your situation is better.
First of all, I would like to thank you so much. Thank you all for inviting us to this very interesting forum. This is the first time that Israel is here, but I'm sure that we will come here from now on an annual basis. I want to thank Dmitry Kiselov, the director of Kaliningrad, my good friend that escorts me here, and I have to say that Israel is a new country, but we have some things that we have heritated from the past, and I would like you all to see. When I was in a restaurant last day, somebody told me, how is it to live in a country that the Bible is the law? And I said, okay, you don't understand something. The Bible is not the law in Israel anymore for 2,000 years. So I'll give you a short perspective about the Israeli law. Israel is a common law country. The legal system, we have no Jews, because when the British came to Israel, they thought that we have to deal with common law, but we can't deal with Jews, because the people of Israel then were not apt to be Jewish, and we heritated it. So it's a common law system without Jews. We have a very independent prosecution and judiciary. Just for example, we prosecute even cops, prosecutors, judges, and even probably you have heard the former prime minister and the former president of Israel was convicted. We're relatively unaffected by the global financial crisis, the growth in the real economy, high-tech, military, industry, tourism. By the way, there's no visa between Russia and Israel, so I'm inviting you to come. Agriculture, and we have a very conservative financial regulation. Professor Stanley Fischer, if you heard about him, came from the United States to be the head of the Israeli bank, and he's very conservative, and I think that we passed this financial crisis, and I hope that we will still be able to do it. Okay. How we deal with the crime. I wrote here organized crime, but there's no really organized crime in Israel. Our major criminal risks is local criminal gangs. It's like a gangs of a family gang that mostly do regional drug trade, human trafficking, illegal gambling and extortion. We still have to deal with corruption, not in big deals, but we have to steal, and funds of unclear origins that laundered in Israel. What is the challenge then that we had? We have FIUs, especially administrative ones, which are focused on the suspicious nature of the financial activity, not on the predicate offense. Law enforcement agencies primarily focus on the predicate offenses, and tax authorities that primarily focus on revenue. And what's under the radar? Under the radar is laundering through legitimate business. A lot of legitimate business are laundering money. Non-profit organization, money service businesses. Now the problem that we had, that each of these FIU, tax or police, each of them worked by itself, without any cooperation between them. I have to think about what are the reasons. Probably the main reason is the need to keep the privacy of the person and not sharing information about it. But the truth is that there are other reasons, some like ego, credit. Each of the authority wanted to do the work by itself. And it was quite hard for us to change this mode and make the FIUs, the law enforcement, the police, and the tax authorities work together. And we needed even, I will show you that the government will deal with it. The solution that we found is a fusion center. Designated task forces creating interagencies cooperation, overcoming the legal impediments of the information exchange, and FIU spontaneous disclosure. If you see here, yes, the government of Israel have decided to focus on illicit proceeds, its primary long-term objective in the combat against serious organized crime. I mean, the government decided to change this perspective that I told you about. All relevant enforcement and regulatory agencies are required to operate in unison, subordinate to program objective and work plan approved by the Executive Committee headed by the Attorney General. The Attorney General in Israel is heading the committee. There is an interagency implementation committee headed by the chief of the police. There are interagencies intelligence fusion centers and 6 multi-agency task forces. Yes, I see it at the time. Okay. The fusion center is composed only of 9 persons. 3 from tax authority, 4 police officers, 2 from the FIU, 2 from the Securities and Exchange Commission. And the architecture is like this. This fusion center is located in the police headquarters and commanded by police officers. There is an isolated glass cubicle for each participant agency provided with secure online access to database of member of agencies. I mean, they sit together, but each of them, in order to get the information, have to ask and see if we can give this information without hurting the privacy. And this small unit, I think, that solved most of the problem that we had, because when people sit together and doing jointly with one aim to fight the economic problem that we have, not economic crime that we have, they reduces the crime in a great measure. I don't want to talk about the models. So the connection between FIUs, police, and tax authority is the basis for fighting economic criminal activities. Another problem that we had is in the old way of thinking. We wanted to take the criminals and put them in the incarceration, in the jail for a long time. We changed our thinking because we have to get to the money, because all kinds of these activities are, the goal is to get a lot of money and use it in the laundering position. And we have changed the thinking by going to the money by confiscation. Seizure of the money in the beginning of the process, of course with court orders, and working together, civil and criminal, in order to fight this problem. Okay, this problem that we have. Okay. We have some problem because we are a common law country. We have some problem with evidence because the laws of evidence are very old. So what we do, the prosecutor, he leads the investigation. I mean, the police officers are inquiring, but the prosecutor is staying with them in order to see that all the evidence will be good for criminal and civil litigations, and it helps very much. The interagency cooperation helps us as well, and we try to lower the standard of proof for confiscation, because when we lower the standard of proof, then we can take the money up front. Now we put the money aside, but in the end of the process, if he's convicted, then the money is with us. Okay, thank you so much.
Спасибо, господин доктор.
Thank you, Mr. Doctor. We suspected that you're very wise people, and we decided to charge money from businessmen rather than punish them, sentence them. If I understood you correctly, we know your approaches. You decided not to be as severe to economic crimes as compared with terrorists, etc. You're loyal to businessmen, punishing them with money and stimulate the development of business initiative in the country.
It's not that we have decided to be nice to businessmen and only take money from them, because then it will be quite easy and everybody will come to Israel in order to commit offenses, because it costs you money. We're doing it both ways. The way of thinking has changed to confiscate the money in the beginning of the process. After you take the money, then they see. I'll give you an example. If somebody is dealing with drugs, he brings drugs to Israel and sells it to kids. He's doing it only because he wants to have a lot of money. Now, he lives...
Я прошу прощения, продажа наркотиков вряд ли это экономическое преступление.
Well, selling drugs is not an economic crime.
I understand. He have a lot of money. And now, with this money, he give loan to the other criminals, because this money is not... you have to launder it. So this is an economic crime. And he lives quite well with new cars that registered on his mother that doesn't work for 30 years. And what we do is, in the beginning of the process, when we start the investigation, when we have enough evidence to confiscate the money, we confiscate money, his car, his apartment, and everything. This is the first stage. Now he's in a good problem now. And now we start simultaneously the criminal charges against him. Of course he will be, if he will be convicted, he will sent to jail. And according to his offenses, to a lot of years. But what we have changed is not only to put them in the jail, but to take the motive that he's working for, which is making a lot of money. But people do go to jail for a lot of years. Okay?
Спасибо, господин Ротков. На самом деле, все...
Thank you. Thank you. I understood you correctly, actually. We in Russia started along the same lines. In corruption crimes and bribes, we introduced penalties to deprive the person of the economic benefits of the crime. For instance, if he sought billions of bribes and is fined only several thousand rubles. But we have another norm now which allows to pay a five-fold penalty, and then the person can be exempted from criminal prosecution on economic crimes. I would like to give the floor to the person who is very knowledgeable in law, Ms. Shatikhina, and listen to get back to Russia and the opinion of science to what's happening in criminal policy, and then we can move on. Natalia, can you describe the situation to us? Good morning or good afternoon. I prepared a very good presentation about the criminal policy in Russia, not only because I teach it, and not only because I'm a managing partner and expert in economic safety and stability of investment. I earn money with this. Not only because I'm an expert at the Ministry of Justice, and now we are through with the monitoring of law enforcement. I was responsible for criminal law, and my colleague sitting there in the hall was involved in the criminal process. We are now preparing the report to the president about the changes made as a follow-up action. But I also teach criminal policy to students of the best legal institution, St. Petersburg State University. But since in the first presentation we heard a lot, I will change my presentation. One after the perestroika, at the beginning of perestroika, foreigners came to Russia, first of all representing Western Europe and the United States. There was a myth in the United States that bears are strolling in the streets of Russia. People are wearing fur caps with balalaikas and know two words, "Tavarish" and "Na zdarovye," but this time is already over.
At that time, most of the Western citizens and they began to understand that our country is not like that. And now there are a lot of myths and allegations about the criminal life. It's not a perception of Nazdarovia and Blalaika and bears, the straits, you know. But basically, what I want to do, I think that the main mission of Russian policy is to put in check crime rather than the legal authorities, and the crime in Russia, economic crime, growing, and the indexes that you saw in the tables that's the statistical data that were published by the Ministry of Interior that showed my lawyers will understand me. It's the negative increment, the dynamic of crimes. It's not an absolute number, it's dynamic values in the past years. The year 2011, negative dynamics was 2.6%. It means by 30% per year, the number of... why does it happen? It happens because the latent various economic and corruption. I do not want to go into the economic crimes separately from the corruption cases, because they are two sides of the same coin, and it's one of 10,000 crimes. It's the same first premise. The second premise I want to come up with is that basically it's economic crimes do not cause any harm to anyone, and probably there is no need to apply such sanctions as in incarcerations, for example. And I do not want to show you the actual changes in the criminal code. Segments have been taken out of the criminal code. With regard to the prosecutions, it's various illegal circulation of oil products, and also sham or counterfeit fuels. In St. Petersburg alone, 350 tests were carried out in St. Petersburg, and not one single sample proved that it complied with the technical specifications. Not one single gasoline that you bought, complied with the requirements, and his fourth did not had a different octane number. So it's what happens with all cars, and passenger travel, commercial travel, haulage. It happened. It was not involved in what happened. Let me try to explain to you why I'm not very much against the changes on the global basis. I will only speak about the problems that Russia had to face First of all, the approaches were not systemic and non-professional, and when we asked who was against it, whether they heard it or not, but criminologists are against it, and judges are against it, and various law enforcement entities are against it. All those people who understand about legal law and most of the economic crimes are mega economic crimes, which we, that is, we take the cases which deal with various the constitutional signs of crimes. They were kind of modified, and I have a table here to show you. If you look in this table, you have a difference from 600,000 rubles, which is about $20,000. That is tax evasion from a natural person. That is you underpaid. It would not be prosecuted. That is, you underpaid the taxes to the tune of 20,000, and it is even higher to 30 million to $1 million if currency funds were returned back to the state from abroad. Now, illegal entrepreneurship, illegal business, it's 1.5 million rubles. If you take passenger haulage, if you have those various minibuses that carry passengers that are driven by most irresponsible individuals very often, and we have a lot of accidents, and so they're very much only punished for not observing the safety rules, kind of, but not qualified as economic crimes, and it's various unlicensed transport companies that hire illegal migrants that do not comply to our requirements. This is one thing that you have to face. I have a whole report because I was kind of studying this issue on a very serious basis, and also various medicines, medications, and as well as you can take those medications from various pharmaceutical institutions. They can do it in such a way that it will not fall in the category of crime. So there are mechanisms, and you probably can work that way through thefts and through. You actually can discover frauds and some other cases, and owing to their qualifications, they really cannot qualify those cases as such. And also, illegal use of if you go out of St. Petersburg, explain what I'm talking about. If you look at how nature is used, Karelia and the Leningrad region, you will see a lot of various pits. That is. They was barbarically sort of extract sand, and the cost of a truck full of sand is about 3,000 to 4,000 sand. Can you imagine how much sand you have to sell so that you can raise your revenues to amount to several million rubles? Enormous number of construction organizations, they all need construction sand, and if you go and if you try to find out where the sand has come from, you'll see that most of the sand is illegal. You have construction sites on your right and your left, and if you go and you track a sand sample, you will see that the sample is not purchased anywhere. It was just illegally sort of excavated at one of the locations near St. Petersburg. So it's this kind of crimes. This is entrepreneurship, and it contains a lot of a chain of events, and you only can fix very minor violations of this kind. That is, you can take a certain batch of certain goods, and which would only be kind of a drop in the bucket, if you know what I mean. And it will not sort of, you cannot store the whole thing. Talking about the smuggling, and we really have to deal with economic crimes, and it's very nice that I'm not alone who is doing the smuggling. Smuggling has never been decriminalized. It's a myth, and in Russian Federation they changed the customs legislation, and the Article 188 was sort of deleted from the criminal code. It used to, that you had to pay customs duties only levied on the goods that were legally imported into Russia. But if these goods, such goods were imported illegally, then they are not liable to duty. So it's a different story. So a man, in this case, did not pay any duties for the illegal or goods that were smuggled in the country, and we did not pay too much attention to the facts how this that article wound up in Russia, because it had to be paid duty for, and if you look at Article 194, which is evasion of duties, custom duties, and you don't have to also add status transfer against the shipment against the border. So basically, they applied either first or the second article. What happens in fact? Well, I think that I really want to speak about that, because raiders, we don't have the raiders and raider operations in Russia. If you this is a kind of very populist term. Journalists like to use the word raiding, which means that they kind of capture the company, and it's really so. And St. Petersburg is a leader in Russian raider operations. We had a conference with this regard, and this Horror Legal Week began, and in St. Petersburg they captured the whole streets, captured or seized the streets, if you know what I mean, from this corner to that corner. It belonged to somebody. This is how they did it. And so very much so. It was in the year 2000, 2005, and we understand that as lawyers, it's an engulfment through various illegal operations or legal operations, and otherwise this or that business or territory is captured illegally, owing to the complexity of they could not manage the financial supervision. Institute could not sort of manage the circulation of legal papers. It was a peak of, and then we had a lot of banditism, and it had nothing to do with raiders. What we understand as raiders, it's regular frauds and scams and whatever, and they just counterfeit various packages of documents. And if you look at those at the raider package, which my colleague is proud of, he said that this package reminds me of a high-quality, beautiful fire extinguisher that you have on the wall of a house that has burned down. And basically, the mechanism is supervision of registration of the security packages and so on, so that you have to be absolutely sick, kind of, so that nobody will do it this way. There is a special certification market that is carrying out the changes that occur in the legislation, and we had to speak about that, and what actually happens with the economic crimes, the directions. I want to outline them in brief, because you can speak endlessly about them. The first thing that comes to mind is that, first of all, as a result of not really consistent activities in the area of procedural law, that procedural code, very often Western jurisdictions come into play, and we have escape of capital and goes to the offshore companies, and there's a movement of funds from one area to another. This kind of dirty money eventually you wind up where. And if you take talking about the changes in Article 140 in the Criminal Legal Code, where the pretext for economic crimes with regard to the tax crimes, they only permitted to accept the results of the tax inspections, and it was really beautiful, and no abuse could be possible on the part of the legal entity and to impose the rules of business. But if you look at how they revealed those crimes, less than 10% of such crimes were revealed during the inspections, tax inspections that were carried out by the law enforcement entities. But if you look at Article 140, I don't know why it came from, but there was an Article 192, which was kind of hiding of means that are kind of a debt in the monitoring. And if a person has a result of a tax inspection, but he hides or following that the assets that could be subject to to the state's requirements to be paid, to be repaid. And this is the same crime as tax evasion and sort of this article eventually. Why is it there? Because the the criminal code does not envisage kind of this inspection cannot carry out such a verification of affairs, and basically what happens, according to these articles, the inspection cannot carry out such inspections, but the law enforcement entities that have to check the one-day overnight fly-by-night firms, they're not reasons for sort of initiating a case and for indictments. And when colleagues came from Moscow, they brought statistics of 1 or 2 cases with regard to taxes, and the material, nobody knows exactly what to do with the results of such inspections, tax inspections, and nobody knows how to deal with them and what kind of risks we run. Now let's talk about the positive, not only negative, but it's also positive. Apparently, Russia is in a very difficult situation, and our Western colleagues will probably not understand what it is all about, and the reform and the support of business and the long-time approach that you have to look similar to similar and with economic. You have to apply economic methods to combat economic crimes. That's the way you do it in the West. It's organic in the West because there is a class of businessmen, and there is kind of a stratum, and business is very much kind of a base for the state, support of the state, socially, and probably social layer that's a stratum that supports the state. But in Russia, however, this is the most sort of disliked stratum, and it is really the case. However, Russia ends sort of it doesn't end after the Sokol Road, but Moscow Sokol Road, but it doesn't apply to people only. But we have quite an original business. It's not socially responsible. We have to admit that, and business is not a clean business. Let's put it straight. And the state has to find itself in a very precarious situation. On the one hand, we understand that we have to rely on such people who are most socially active, most educated, and they're globally lean to a liberal way of development. In the meantime, it's not the majority of the Russian population, in the sense that that kind of are approved by the majority, and the state had come to unprecedented and very popular measures. First of all, they had to do with the criminal procedure code. It's difficult to imagine a liberal state in which, depending on the social group you belong to, regardless of the gravity and the magnitude of the crime, if the sentence would be likewise passed on you. If you are head of a construction cooperative, you can be subject to, you can be incarcerated after all, but in case close to this you have a small kiosk, you cannot be subject to you cannot be apprehended, but otherwise the degree of fraud is very much the same. Otherwise we cannot put ourselves in a situation when the most active part of the population is very much criminal, and they evade taxes every day, and they break some other requirements or violate some other requirements. You cannot exist like that, because otherwise you'll have a lot of problems. On the other hand, we adopt mechanisms which sometimes we do it sort of not really judicially, and they do not work. And first of all, we repudiate administrative regulation, and we adopt self-regulated organizations, internal corporate mechanisms and responsibility, and whatever. Globally, we can welcome them in every possible way, but how do they work, and do they succeed or not? If you take self-regulation in construction business, I'll be in a nutshell and say that I have only 1 minute, but it did not work at all. You have very big problems with auditing activities. You don't have the standard auditing standards, and you don't have any rigid standards, and most of the problems are in the fact that we pay attention to that. The reason why we had default of this so many papers in our stock exchange, because there were a lot of securities with regard to which were subject to default because they were allocated in London. There was quite a big share of them, and there is a big difference between international accountability and Russian business accountability, and as a result, basically, small businessmen had to suffer.
Those who bought securities believing them to be stable, but at the same time, when the issuers found it inadvisable to pay coupon debt yield, all companies were in default. And all of them were managed by the pension fund, and those securities were in the stage of artificial default. The number of bankrupts increased fourfold. Some of them were intentional bankruptcies. Very few companies were bankrupt for economic reasons. Most of them preferred not to pay money on their obligations, which is a positive thing. Is fighting with one-night companies. There are 2 articles of the Criminal Code, which is a positive thing, which improves the business and interfered with good competence practices. Like in the U.S. legislation, if I name Martha Stewart, what our colleagues would say? How much did Martha Stewart got using inside information? Was it 30,000? I don't remember the figures. I think $30,000. That was her profit from her crime, and she was isolated from the society. I think it was a short-term 6-month sentence. Well, one of the persons working in the investment bank, all leadership of the bank during the 2008 crisis, in accordance with the records, increased their own packages 400 times. Is it insider activities? A person got a small preference and paid only 4 million in penalties and spent 4 months in prison being a public man. Now you see the difference and responsibility of the business between the United States and Russia. Thank you, Natalia. Even the speakers, not only participants, became more active. And I would like the speakers to wait a little because we are going to get back to the discussion. As a moderator, I would like to say a few words. First of all, I was unlucky. I was not Ms. Shatikhina's student, but fortunately, I was first deputy of the State Duma Committee on Criminal Legislation in the State Duma. Therefore, all the amendments, modernization, and all other incentives passed through me. And therefore, I can assume all the compliments and all the criticism for the new legislation. Well, the government of the Russian Federation was against this law, nevertheless. Well, actually, entrepreneurship in Russia, like in any other country, should become the support group, which we cannot shape so far. First, it was forbidden. Nobody could even think about it. Then it was unpopular among the people because it segregated the people. Then there was legislation which was good enough, but the enforcement bodies started to implement it in a way that it was dangerous. It became dangerous to be a businessman in this country. Well, business is a very risky thing in Russia because he can go bankrupt, and not only because of this. I mentioned this to Anatoly Medvedev. So there are 2 trucks, for instance. One just carries goods, and can carry money and know in it, and nobody will know it, and nobody will armor this truck. But the other truck always carries money, and the criminals know about it. And this truck is the the bankers' machines. It is always armored because all criminals know that it carries money. A businessman, unlike a common citizen, unlike any other profession in the country, like a doctor, teacher, or miners. So why different measures of restraints? If somebody did something and he can be put into remand, though I believe that nobody should be put in remand if he did not kill anybody. Well, what's different about businessmen? Because bandits and enforcement bodies, well, making this comparison with the truck, they always know that there is money in it, and all the laws are against the businessman. While he's sitting in remand prison, his business will be snatched away from him. And this way we destroy this support group of businessmen. Well, we say, let's go, put away your bottle of vodka and engage in business. But you just started your case, you owe everything to everybody, but in the long run you can find yourself in prison for a long time, for 10 years, for instance. And you have to fight this kind of enforcement with such amendments which are probably not legally correct. But at this stage, this is a forced measure and it is necessary. Let's continue our discussion. Our colleagues participate in many of our sessions. Unfortunately, while speaking about science, at parliamentary hearings, when we discussed those bills, it was very difficult to come to consensus with academic circles. But we do not idealize the situation, nor you idealize the situation. Well, the State Duma just works for this at least 3 days a week to amend legislation. Where enforcement goes the wrong way, we are going to change it. So we're not going to stay in one place. And sometimes at parliamentary hearings are attended by our foreign colleagues. Mr. Firestone came to Russia several times, to the Duma several times, and we discussed this problem several times. When businessmen are illegally brought to justice, fraud, Article 59, which is a universal norm, and sometimes it is unjustly applied. If in Article 22 of the Criminal Code 10,000 people are prosecuted, Article 159, Chapter 21, 40,000 are prosecuted. That is 4 times more than in all other articles. So I would like to give the floor to Thomas, who is knowledgeable about the topic and has his own, I hope, objective opinion. I don't know how objective I will be, but I will try to be so. We have been having so interesting discussion, and I don't know how to start. So let's start with thanks to Andrei Gennadievich for inviting me to participate in your event again. As you rightfully said, it's not the first time I participated in such discussions, and discussions are always interesting. Today's is not an exception. First of all, let me tell you that Martha Stewart was not sentenced for abuse of insider information, not for fraud, but for false testimony. That's why she got this 6-month sentence. And I quite agree with what Andrei Gennadievich said. It seems to me that entrepreneurship, wherever you see, is the support, the column, the stone of a democratic country. So it's important for criminal legislation to protect the businessmen. Without at the same time preventing the fraudsters from harming the society. It's very difficult to find this boundary. I think that the trends you mentioned at the beginning of today's session about humanization of legislation is very important. Unfortunately, nobody in the West knows it. If you read the Western press about the Russian system, you can read a lot about the Yukos case, the Magnitsky case, but you will not see anything about the progressive trends about humanization of criminal law in Russia. I think this information should be spread. It should be communicated, and I want our journalists in the West to write more about it, because it will give a positive signal to Western investors. There are a lot of difficult issues here. Well, humanization of criminal legislation. This has been done to fight corruption, to fight raiders activities, to prevent abuse of criminal legislation by enforcement bodies. I think it's the oldest question in political science. Plato asked, who guards the guardians? Who protects the people from the guardians? Since Plato's times, nobody found the final answer to this question. But there are different attempts to protect the society from such abuses. I can tell you how it is done in the United States and what are our best practices. I worked there before I came to Russia. I was a prosecutor in New York and worked under Loretta's guidance. She was my chief in Brooklyn. And in our office, there is a very strict control over the activities of prosecutors. When we charge somebody on most severe articles, you call it a criminal society. We call it RIGO law. It's very severe instrument which envisages heavy sentences, arrest of property, and in order to put charges at this article, one should get different evidences and proofs from a special, including special office from Washington, from the Ministry of Justice, to avoid abusing this article, because there is such a danger. It is very important, and we should always get the confirmation, the proof of any accusation, of any charge, and the federal prosecutor has to sign or to confirm any prosecution, that she controls other prosecutors working with her or under her. There's another important issue, another important thing in our practice. As Konstantin said, when we are speaking about reforming criminal policy, one should pay attention not only to substantive law, but also to procedural law. Here, I'm saying that the most reliable protection from abuse lies in the criminal process, not in the substantive law. The bureaucrats, if somebody wants to abuse, he will always find a way. You can rewrite the criminal code many times, but if there is such a mentality, if there are such intentions, the criminals will always find a way to abuse the authorities. So one should not leave aside this issue of criminal proceedings. In the United States, from the very beginning, we had the jury court dealing with all cases, including even civil cases. This is very important. Well, because the existence of the jury in all criminal cases makes the enforcement bodies to take into account the public's opinion when taking a decision about starting a criminal case. When we're preparing a criminal case in our office, we always ask ourselves, how will the juries respond to this charge? And if we think they will react improperly, if there are no convincing proof, or if the juries think that the crime is only a petty one, we shall not instigate the case and drop charges on this case. That's how the public, the people, participate in the supervision over the enforcement body's activities, which is very important. And the third thing I would like to draw your attention to is what Loretta said about U.S. legislation about sentencing guidances. We have a special law on sentencing guidance which obliges the judge to make a calculation. There is a mathematical formula to calculate the sentence. Every crime is assigned a certain number of points, and then those points are added up or increased or lowered down in accordance with mitigating or aggravating circumstances. So the sentencing process becomes very transparent. The judge should motivate any sentence, and it can be explained by this scale. He should explain why so many points were given for this crime, why he added points or deducted points, and the defendant can challenge any sentence on the basis of this law. And I think it's very important because this makes sentencing process very transparent and protecting the society from arbitrary actions when sentencing, and provides equality in the process of sentencing. So these are the major features of U.S. justice. And that's what Russia should do. While I not claim to be the one expert, there are too many other Americans who want to make Russia do something, but I don't belong to such people. Thank you very much again for the possibility to participate. Thank you, Thomas. Yes, you frequently participate in our sessions, and we find your viewpoints are very useful. At the beginning of this roundtable discussion, I said about reception, we borrow a lot of norms from other countries, see how this or that norm develops and how it works in other countries. It's very important, especially important about fraud, because it's in Europe and in the United States. And there are several elements of crime, and we in Russia have only one article with qualifying features, but still there is only one article which is too broad and which is too universal, but we started to work on it. You might have heard the Supreme Court of the Russian Federation submitted a bill which classifies frauds into 6 sections: in the banking sphere, in the housing and utilities. The deputies have their own version of the bill, so this will be changed in the near future, which is quite correct, because you can't wait forever. We can't think that we can do without changing the article. We have colleagues from Great Britain, and I think it would be good to listen to their problems, and whether they have problems in enforcement or in the criminal law itself. Mr. Simon Davenport, you're the royal advocate, royal lawyer, probably have a lot to say to us.
May I congratulate you on the legal forum that you have here. You really do have the opportunity to become the leading legal forum in the world, if you're not that already. Can I say very clearly that, if you'll permit me a soundbite, for the United Kingdom, Russia means business, and increasingly, business means Russia. Now, I'm not a criminal lawyer, may I make that very clear, but I do practice in a lot of cases which involve civil fraud. One of my good friends and colleagues is at the other end of this panel, Mr. Yuri Bochuk, and we work together on a lot of work, including a lot of work, it should be said, from the Russia of the 1990s and other cases. Now, that's not unimportant, because it seems to me that the relationship is not the same in Britain as it is in Russia between the criminal code and the civil code. Obviously, we don't have codifications, we have a common law system. But there has, it seems to me, in Russia, been a predominance to lean upon and follow the prosecutors in criminal actions, and to take the lead from the prosecutors before bringing civil cases. Now, as you stand on the bridge of changing your civil code, which itself was redrafted in the mid-1980s by international lawyers, including representatives principally from Germany, from Britain, and of course from Russia, there is an untapped well of possibility, and I encourage lawyers whose practices cover both civil and criminal cases in Russia to be aware of the autonomy that exists and has not been fully used by civil lawyers in this country, in particular for the use of actions of civil fraud. And I direct your thoughts to the proper use of Articles 1064 and 1102 of the existing Civil Code. A bit like an iceberg, what you see is only a small fraction of what there is in those codes. I'm going to talk to you a little bit, therefore, from a civil fraud perspective, looking at our criminal system in the UK, because we do have problems. And the normal treatment of crime in any country, particularly in fiscal crime, does not just involve, as I've heard today, punishing crime and remedies to deal with people who are the victims of crime, but I think increasingly on the attempts to limit the incidence of crime, prevention by law, by control mechanisms particularly, and by regulatory conduct. The history of prosecutions for fraud cases in the United Kingdom has been, to say the least, up and down. The Serious Fraud Office, which is one of 4 of the main prosecuting bodies in the United Kingdom, started off with a spectacular triumph in a case that came to be known as Guinness 1 in the end of the 1980s. They used the very best legal minds and the very best administration to put together a formidable case. And the boundaries of this case had to deal with the defence put forward, which was that within the city, the alleged misconduct was no more than what everybody else was doing. So the first thing to think about while we explore this issue is the question of perception. Because if you have a speed limit on a motorway and you exceed the speed limit, we all know you're exceeding the speed limit. But conduct and activity is interpretational. And this uncertainty, this ability to say that activity should not be regarded as fundamentally dishonest is one of the major hurdles that economic prosecution faces in the United Kingdom, and I suspect other jurisdictions as well. Now, having succeeded in that way by throwing resources at the situation, I tell you recently, some people in this room may know, that a prospective England football manager, Harry Redknapp, was prosecuted by another of the bodies that bring prosecutions in economic crimes, Her Majesty's Revenue and Customs, the tax authorities. That was an investigation and a prosecution that cost the British taxpayer, including me, £10 million to bring. And it was seeking not the repayment of the money, because the money had already been repaid. It was seeking a punishment of a well-known, much-loved character who was very much in the public eye. That prosecution failed, even though part of the main aspect of the case involved that Mr. Redknapp had set up an offshore account in the name of his dog. Notwithstanding this brilliant piece of information, they were not able to succeed. How can that be? It was plain on the face of it. I think the HMRC would tell anybody who wanted to listen that there were any number of charges that they could have brought against him, but this was the most secure of all of the charges. In respect, therefore, of £100,000 or less, a £10 million public failure was the result. These are the hurdles that even the strongest case has to overcome. However bleak and black it may all look, ultimately these crimes have to overcome a test of dishonesty. That test of dishonesty is set against the background that the prosecution bear the burden the whole way through with no presumptions helping them. In England, Britain, we have a high standard of proof. The prosecution has to be proved beyond a reasonable doubt. Increasingly, we have the problem, which is that the petty, small cases aren't worth bringing. But the big, high-value cases are losing on the war of funding. The defendants in big, high-value cases are almost by definition always going to be well-funded. And they're always going to be better organized. And so the prosecution, the state, faces the extraordinary position of being outclassed by way of funding and organization in respect of the category of crimes that they should be bringing, which is a bit of a problem. This failure led the British authorities to turn to the Americans. And as my colleagues to my right may remember, there was an independent review of the Serious Fraud Office asked for by the SFO in 2008 by the New York city prosecutor, I think Jessica de Grazia. It reached the following conclusions. The SFO, the English organisation, achieved a conviction rate, and it should be said, of those that they managed to bring to court, of 61%. The Manhattan District Attorney's Office achieved a rather better 92%. Now, efforts have been made to try and rectify that, and a similar but internal review was taken in 2010 to 11, and the rate had risen to 84%. But the problems that were identified by the Americans of the British system of skills shortage due to the immaturity of the independent prosecution agencies and the failure to keep in-house advocacy or all-round court experience still obtain. There have been successes and there have been failures. I just tell you one of each. In a case brought against BAE Systems under the bribery legislation that preceded the Bribery Act, a settlement had been reached by BAE with the Tanzanian government in respect of a Tanzanian bribery. They promised to pay £30 million less any fine imposed by the criminal court. Faced with that, and with the promise to review their activity, the criminal court fined them £500,000 for a monumental investigation. A relatively small sum, one might think, against British Aerospace's pocket. Is this a triumph? Is it not? The case which is plainly not proving to be a triumph is a prosecution brought against the notorious Cengiz brothers in the United Kingdom. And Vincent Cengiz, one of the two, the more voluble of the two brothers, has actually gone on the counter-attack against the SFO, suing them for £100 million sterling for complaints that he has in respect of execution of search warrants and the effect it had on his business interests, he claims. The criticisms made by the court were fueled by the fact that Vincent Cengiz was able to hire no less than Lord Goldsmith, who was the former Attorney General in Britain. Now, in part, the problems are clearly budget-related. The £100 million that was being sought against the SFO was an enormous chunk of the available budget. The budget itself has been cut by 30%. Morale is accordingly not high. So faced with these sorts of issues, what is actually being done in the UK? Is it all bad news? Well, it's not, but I think the focus is changing, and I think the focus is, as I advertised at the beginning, on control, regulation, and other forms of remedy. Now, the money laundering regulations have been changing almost on an annual basis. The current crop that we have, albeit with some subsequent amendment, are the 2007 regulations, something I come across a lot in my own civil fraud practice. This is applying to most business sectors. It's supervised, and it involves the normal money laundering processes of assessment of risk, of insurance that there is compliance by having a mechanism within each business sector company that has to report wherever there is a disclosed suspicion.
Может быть, к завершению, чтобы мы уложились.
Suppose we want to encourage you to come to conclusion, because we are coming out of time. I'm sorry to remind you of that.
So I will just conclude then by saying that it's my own view that there will be more and more reliance, certainly in the next 5 to 10 years, of these types of regulatory procedure faced with the problems that I've outlined. Some work I do a lot has been VAT fraud, and VAT fraud, which costs billions to not only the UK but also to Europe. 40 billion is the biggest single fraud that's perpetrated in Europe and is ongoing, is being increasingly met by civil remedies, by injunctions to close companies down and to stop the fraud from going any further, and from taking further action by tax courts not recognising set-off of the ability to claim VAT output from input. And I think that that is going to be the direction that all common law jurisdictions at least are going to have to look at. And my feeling, as I reiterate, as I started with, is that I feel that the weight of the balance between what happens in Russia, between civil code remedies and criminal code leadership, will adjust, and probably is adjusting at the moment. And it may be, I hope it does better than it is doing currently in the UK, but it may fall closer into line with having to recognise the availability of civil remedies in an otherwise criminal jurisdiction. Thank you very much.
Спасибо, господин Давенпорт. Спасибо большое. Интересная информация, на самом деле.
Thank you very much. Your information was very interesting, and it was very nice to hear it from you. Now I would like to ask a Russian lawyer, Andrei Porfiryev, from your perspective, what do you have to confront or to face in most situations? It's the issues of legislation or the application of law. Let me also tell you that bears do walk the streets in Moscow, and you still raiders every now and then, and I was kind of surprised by my colleague's presentation a month ago. Another factory was kind of captured or seized in St. Petersburg, and they say that such kind of crimes based on fraud, we had a lot of, if somebody said that it's only a madman can commit such kind of crimes, they said, but I have plenty of madmen that do commit such crimes, and practically what we have to come to grips with is that in most cases the problems lie in the application of law rather than the legislation per se. But I would like to emphasize one a certain aspect. It's not very much that you speak about the legal law, but the sort of discrepancy between practice and law, and many diligent entrepreneurs that don't have any other choice than to go to the law enforcement entities and to bring a lawsuit, and they don't have sufficient proof in order to bring it to the court of arbitration because they don't have any adequate mechanisms to collect evidence, and they cannot apply the article of the criminal code, which would be abuse of trust and confidence situation and so on. But you know that the changes are being adopted, which are also sort of expand the application of such articles, and we hope the system of arbitration will eventually come to the foreground, and they will permit the businessmen to uphold their interest in the court of arbitration, because if it is done by fraud, it's very difficult to find copies of documents which are associated with this or that case. In this case, what we have on the surface is the problem of corruption of the law enforcement bodies, and when they see that a businessman is interested in indicting some other entity in order to protect his interest, some of the not very ethical law enforcement officers, they would sort of within a criminal case, they would offer such businessmen the measures of the reaction that make it possible to take away business from his adversary, kind of. And you can see in Article 201, they would also indict it on the case rather than on Article 159. So in order to interdict the economically oriented crimes. So in our daily work, if you take Russian lawyers, our principal task would be to reform civil legislation, given stability of criminal law, the framework of the arbitration mechanisms to protect and uphold the interests of private business. I'd like to also add that in this country last year we set up a center of public procedures, that is business against corruption and raiders, and we set up a council that includes various experts, and any application of any businessman who is subject to an attack is very often due to an ethical application law, and the expert council would address it, and if the interference on that level is not sufficient, then there would be an advisory board which would include several representatives of the government that make it possible for this public center to become an influential institution. We have first positive examples that we managed to obtain, and in this hall you have, especially for this purpose, high time lawyer Yana Yakovleva, who is chairperson of this non-commercial partnership Business Solidarity, which is who is involved in protection of businessmen. He is co-chairman of the center, and she also had to go through all the sort of pains of business adventures in Russia. So I want you to share some of your examples. Probably you can give some positive example as well, which you have. Thank you for the invitation, and I would like to say the co-chairperson is Andrei Porfiev and Andrei Zarov. So I'm not alone.
So I'm not alone at this center, and I cannot but respond to the correct words issued by Natalia. And that gives us ground for thinking, first of all, Russian businessmen are not thieves and criminals. And probably the problem does exist, but it is not so great. The problem is that Russian enforcement bodies push the business into this criminal sphere and criminalize any action. So I'm in no way the proponent of expanding criminal charges until we've done away with corruption in this country. But when it happens, we do not know. And let me draw attention to the presentation made by Andrei. The figure was about the frauds. It's the number of initiated cases, 150,000 crimes or charges per year, whereas about 30,000 only make it to court. So the difference between those 150 and 30 is the activities of the enforcement bodies. So 100 and more cases are the cases initiated for the purpose of corruption and extortion. So the figures are different from the US figures, where we have 542 which made it to court. Americans deal with the federal level, large-scale crimes dealt with by the federal agency. Well, minor cases are sort of private cases. What I wanted to say is that any economic activity is treated as fraud, and the two lines that we have in the criminal code, they do not allow us to deal with real fraudsters, but allow the enforcement bodies to kill businesses, because these articles should be changed. That goes without saying. It's one of the major objectives, because all cases we deal with in our center deals with those enforcement practices which are terrible. If I describe certain cases, and when you observe such cases and you read the indictment, you understand that the Russian judicial system is broken, is destroyed. It does not work because businessmen are tried for getting profit. Getting profit is called extracting mercenary interest or embezzlement or intent of fraud. For instance, a businessman whom we managed to save, we went to Astrakhan to have an SI session, because in Astrakhan there is a trend that construction companies People working in construction companies were put into prison, just for being in business, in this construction business. All of them were put into prison. They took the acts of work performed. There's a list of work operations done. Then the so-called expert came to the site for 10 or 15 minutes. So-called the woman with a 20-year experience of working in construction industry, and she said, "I think that this hole is 30 meters narrow or 30 meters broader, and this ceiling in the here is longer, and two redundant bulbs in this." Well, probably they found where the embezzle was and whom the money went. No, they did not discover anything like that. And the conclusion was that this thing cost so much and so much, so he stole so much, so the whole is worth so much and so much, and the person was sentenced to 7 years in prison. I was amazed. I think that's the end of Article 159. Yes, he was tried under Article 159. It's clear it's corruption, and it's clear that our criminal court rubber stamps any case and indicts and convicts a person. There was no victim in this case. It's just practice. It's not just one case, it's a system. Every Russian businessman should know that that's how they're going to treat him in court. Well, the victim comes to the so-called victim and said, "We are happy with the renovation, or there's nothing to put the construction company in prison for," so they do not take into account the victim's opinion. The victim says, "No damages, I'm quite happy with it," but the court does not listen to him. So we managed to save this person. I told the president about this, to tell the situation. Only this publicity allowed or forced the court to take the correct decision. The court actually took the right decision. They dared to do it. Now getting back. So all Russian business belongs to the criminal jurisdiction, so to say. The arbitration courts, which give 28% of acquittals if the companies turn to the arbitration court, they give 28% of acquittals. And when we manage to transfer cases to the arbitration courts, then probably there'll be less corruption. But now the Russian businessman cannot hope that the court will make an attempt to make a just sentence. Well, using this businessman from Astrakhan as an example, one of the bureaucrats in the oblast started construction business, and he wanted to get rid of the rival. Well, stop behaving. We have one more presentation. If the top official started a construction business, he involves the enforcement business. He instructs the enforcement bodies. There is the order from that bureaucrat. The rival businessman is put into prison. His business is ruined. Yana, thank you very much. I understand all of us are lawyers with a good record of work. What we're discussing was not the legal explanation of this or that. We are just mentioning the fact. Afterwards, every expert, every speaker can have a say afterwards. Well, what Yana is saying, she focuses her attention on most outrageous cases. Well, I would not say that it happens everywhere. And I invited Janet for the open government session. And she said that the situation is even worse. Well, certainly in order to protect somebody, the lawyers for defense should, sort of describe the situation even worse than it is. Every fifth businessman decided to leave the country, and the main cause is lack of legal protection, including safety, security of business. Every second does not rule out that he will leave in future. It's a serious problem for the country. But to support my country, I would say that the review, that a questionnaire conducted in Britain gave about the same figures, because businessmen would like to get even better conditions than they have now. They want to change the environment because their financial activity allows them to do so. So it's not typical only for this country, for Russia, just to calm the passions. This social institute we managed to set up is necessary. Those are people who can, to whom you can turn without any filters. We invite lawyers and experts, and we take decisions. If businessmen try to resolve their own issues between themselves using illegal means, what do we have to do with them? Yana was describing cases when we came to Astrakhan with enforcement bodies, the prosecutor's office, the investigative committee and police, and the other side were the businessmen and the victims, and we started to ask questions to the so-called victim. And he said, we have no claims, these are our extra budgetary revenues, we are pleased, everything has been done properly, but FSB decided to start a criminal case, they did it. They paid for the review. So there was no doubt what was happening. And the same cases happen in other sectors. But I hope that it's an isolated case. What I mean that, well, the businessmen are not arrested right in the streets and put into prison, but the trend is not good. We have another guest, Mr. Batyuk, from Great Britain. Do you have anything like this? I mean, social institutions for the protection of businessmen and businesses. How does it work? If the businessman comes across the state or its corrupted representatives.
Deal of opportunity of protection to businessmen, especially Russian businessmen. We call it asylum. So that is how we deal with it. The issue that occurs in Russia, from what I understand, is that everything has to be brought to the General Prosecutor's Office, even the lowest level, and that amount of low-level corruption and the enforcement mechanism having to be done through the General Prosecutor's Office allows for corruption to exist. Our police force and our enforcement agencies take another view. They're not that interested in work.
Я хотел, господин Батюк, именно вот.
Yes, that's what I wanted to ask. Do you have a mechanism of additional protection of businesses if it comes across enforcement bodies, if something illegal occurs?
But in terms of an additional mechanism where there is corruption, no, there isn't, other than going to another, hopefully not corrupt body and informing them of the corruption. However, as Simon Davenport, QC, has pointed out, and he's taken all my best material this morning, so that's why he's taken that. But the main thing for us is that the police aren't interested if it's less than £700,000 of loss. The police aren't even that interested if it's more than £700,000 worth of loss, because the whole foundation is for the victim to actually get his money back. The Serious Fraud Office has had serious difficulties in terms of being able to prove the fraud cases that are brought. the international recognition of crimes from different countries has also been challenging. So at times, well, Simon and I are working on a case where there is one of the many innocent Russian men in London who is answering cases of a fraud challenge, but not every person in London is also innocent. Russia, amazingly, actually does have some criminals in it. Some of those criminals have chosen to hide their money internationally. Some of that money has found its way through London. It's a fascinating and challenging prospect, but it allows us in London, through Simon's help, and we work together on this, to actively try to pursue those individuals, to try to retain and obtain the assets for the people, the victims of crime in Russia. So it's not black and white. The one thing that one has to bring to any of this from a public policy point of view is that any system cannot be based on corruption. One has to have faith in the officers of the country, in the judiciary, to do their job properly. If that does not exist, you will not have a fair and valid system. And I can't change that with a microphone that comes from the will of the people within the country. The United Kingdom's recognition through this is that there is corruption in the United Kingdom. Happily, it is not very prevalent at all at the judicial level, and that stops matters getting out of hand. We've created this by having a very rich judiciary. So I suggest you have very rich judiciary, because that way they aren't influenced by monetary means. Politics as well is largely kept out of the judicial process as well. It's a challenging prospect. I think the way it's instituted is through the legal education in the United Kingdom, where it's almost you're ingrained with a monastic belief into the core causes or the core foundations that the judges are there to serve and should not be influenced at all by politics. I know we have run way over time, but I think the main points that I ever would have had on this discussion was the fact of using the civil remedies.
Спасибо большое.
Yep, there you go.
Спасибо большое, господин Бондарчук.
Thank you very much, Mr. Banyuk. You're very laconic, actually, yes. Taking into account we have to to involve our audience. Thank you very much again. I would like to say that in addition to the Public Social Center, we decided to set up the Institute of Business Ombudsmen, so those protecting the rights of businessmen, and I hope they will have a special procedural status that would allow them to obtain real mechanism of protecting the businessmen suffering from arbitrary actions, and we are planning to implement it by the end of the year. And I would like to say that we discussed the development of entrepreneurship at the open government sessions, development of competition, including enforcement, changes in enforcement. President Medvedev signed 5 very important instructions to continue changing our criminal legislation. I would like to mention them, but you will find them on your slides. The first is appointing the first offenders in economic crimes to sentence them to deprivation of liberty if they pay the damages, home arrest for economic crimes, excluding the possibility to start a criminal case for economic crimes without the victim's application. That means entering changes into Code of Criminal Procedures, and charges under Article 159 should be treated as private public. As for fraud, we should prevent the possibility of manipulating with legislation, and the Minister of Justice has been instructed accordingly, and this year there will be changes along these lines. I suggest that we express your opinions, and then we go back to our speakers To sum up, о чем они вообще думают? I would ask Alexander Molotnikov, who is the teacher they have the chair of businessman law. He is an active participant of all working groups working on modernization of criminal legislation. Listening to the very interesting discussion, we are approaching the two cornerstone questions. The first is the criminal policy in the sphere of economic crimes. The second thing is the problem of enforcement. Sometimes they're mixed up. However good is the code, however modernized the criminal legislation, if investigators put innocent people into prison and their major goal would be, let me put it, how shall I put it? I'm sorry for this if it sounds. Some corrupted investigators use the expression, come here, new meat. And that is so, that's how they call the businessmen. And we should fight such attitude. In cases of corruption, in cases of violation of businessmen's rights, well, we should not surrender and say that if everything is so bad, whether you change the criminal code or not, nothing will change.
It has to be changed, and first of all, you have to change the whatever relates to the fact that the criminal code very often runs counter to the civil code. We mentioned this fact today, and so long as there is no coordination, no alignment between these two acts, in this case we probably will not have any positive shifts in economy and development of business in Russia. If if the term 3 years is 3 years for the sort of longevity of the crime, then basically what I'm saying, if you take a grave crime, it's a person can be sentenced for 10 years sentence. If, for example, as an entrepreneur, I purchase a certain asset, I want to be sure that there would not be any criminal case, that I will not be indicted for something, after which everything will be taken away from me and I'll be put behind bars for a lot of years, and 8 years later, I know that 3 years would be the I know that according to civil code it's only 3 years, but the criminal code has it as 8 years, so it's not the same thing, if you know what I mean. It's like somebody stabs me in the back, if you know what I mean. And basically we also have to struggle against what Yana Yakovleva is doing and Ray is doing. Sometimes it's not thankful, because you come to a region and in many cases there is quite a lot of negative sentences and invectives they have to listen to with regard to what happens in that region. And the second issue is that you have to think, to ponder over how public could also influence and improve the processes that occur in Russia, and this would be a public council and development of ombudsman and civil rights activists, whatever. And this could help, as I can expect, and I also want to hope that based on the results of our today's discussion, we'll come to the common denominator. We have not come here to argue. We are all of us are good for the development of this economy. Considering that the economy is globalizing, nobody cares where this money comes from. It's from foreign jurisdiction, Russian money, whatever. I think it has to be that way. So probably this would make a difference for the world and make it better. Thank you. Thank you very much so. It was a very good summation. Now, do you have any questions, any of you, any positions, if you want to express publicly? You're welcome. I'm Vladislav Musiaka. I am a lawyer from Moscow. I find this round table very useful, and I learned a lot from the table. What I personally learned for myself is the application law. Russia has a long way to go to achieve the level of the world practice. It's a very, very long way to go to achieve that level. And in the best university in St. Petersburg, in the best chair, we also get the best education that we can. He's talking about the law faculty of the St. Petersburg University. I understand that most of the most advanced ideas, application law, are developed there. In practice, however, Natalia, they do not work. They do not work. Theory and practice are far apart. Now, you listen to Guy Ruth, and I understand that essentially such crimes as frauds and scams, they occur in Russia. You would not have them in Israel. We cooperate with Israeli companies on a legal basis, and we understand that the fraud that you have in Russia, the scope and scale and the magnitude, you can never find it in Israel, for this matter. And it was very useful to listen to the American prosecutor, because what I understood for myself is that we discuss in Russia very broadly the issue of indicting legal entities and companies, and if a company or corporation could be indicted, it means that then they really have to think seriously about the consequences. The consequence it may have, such a decision may have, and that is I do not want my country to think in such terms, but I really want to think. These people have been doing a lot, and a lot of useful things. And if our law works here and the institutions are working adequately, and the public supervision also is effective as the way it has to be, then I believe that the law, which is developed and adopted by the Duma, they are nice laws and lies, but they do not work. They have no effect, neither in Moscow nor in St. Petersburg. Dmitry Vasilchenko, Moscow. It's a bar association. I want to use this opportunity. I want to ask a question to the ideologist for liberalization, Mr. Nazarov, first and foremost, because I did not really understand. First of all, article on fraud. I want to apologize to all the colleagues. It's probably gospel truth, I want to quote you what it's all about. It's kind of a con game, and it's I didn't want to give you the definitions. You understand how it is, what it is associated with, and otherwise stealth is felony. All these things, the definition. Do not want to repeat here. But anyway, when something is taken away from somebody, in this particular formulation, that is taken away property from somebody through a fraud operation, what needs to be done so that you go in the right direction? What has to be changed in this particular article? The second thing is I want to ask you, Mrs. Yakovleva, and it was supported by Mr. Nazarov as well, we're saying that Russian law enforcement and judicial power, if judicial power was supposed to eradicate the mistakes that were committed by the law enforcement bodies, otherwise they give hard time to business, and the message, ideological message, is to change the situation, to amend the situation, to this corruption component would in judicial power and law enforcement bodies would no longer be controlled, and the legislative authorities, they do not comply with what the state requires of them. And when you change code, article code, the lower level of fraud, and let me tell you also various crimes, injuries, which there is cases with mortality are sort of equal to zero. But when you speak about liberalization, I think we have to speak about the upper threshold, but so long as all the articles begin from 0 to 5 to 7 to whatever, I think this probably is the corruption component. You say that the judicial power is giving a hard time to business, and you give them a lever so that they would be sort of working with business even more effectively. That is, he would have a choice between 0 years and 9 years, for example, and they don't have one single, and the person gets 9 years for whatever. So it's when there's no kind of lawsuit, and then he gets the sentence, and you give this corruption component, which means that a judge can punish a person from 0 years to 9 years, and otherwise, you understand, there is a choice, and it's certainly a bit of corruption that you can apply in order to. The reason why I'm talking about that as a lawyer, as looking at Mrs. Yakovleva, who is not looking at me with approval. I'm telling you why. So long as there is law, you need lawyers, but when law goes away, you need killers, because they'll start shooting people. If you know, I have been a lawyer since 2000, and the 10 years practices have seriously changed. First I had people that I protected from the law enforcement, and most of all now I have to deal with victims, and we have to do some job for the lawyers, and also to sort of speak on behalf of the victim, because the state can no longer protect their interests. And in pursuing those issues, it's something like an amendment, kind of those transactions that have been carried out based on various contracts should not be viewed as cases of fraud. That is, you register company with sort of authorized capital of 20,000, and he cannot be prosecuted, and people start shooting if it happens this way, shooting each other. Natalia Shutich and I, we discussed all these subjects, and she also used the same phrase: unless we have law, they'll start hiring killers. Probably not that, but I'm also a lawyer, and I want you to once again I was talking about something else. I want to correct myself. We are professional lawyers, and we did not sort of write to compose those laws. We want only to make sure that they really work, and the report that I want to make, one of the measures that the Moscow University chair has proposed, legal chair has proposed, that is taking away a passport would be an alternative to detention, because people are very often arrested because they're afraid that he would get away from Russia and so on. But throughout Russia, there's such a method as they apply it in civilized countries. They take away a passport, that is foreign passport, travel passport from you. That is, you can stay in the country, but you cannot travel abroad. And when I mention the word shooting, there is statistics, and I work very closely with law enforcement bodies. I know exactly what you're talking about. Most of them are quite sensible people, quite sane people. He says, look at the crimes against the people who trust to carry money, and why such cases aren't such cases closed, because very often, you know, these people come from the attackers. If you go to Cherkizov market, or you know, if I go to some other market, I will walk out of it with a killer, because you know, you can have these stabs in the back and strikes by you know, construction rods, whatever. It's small banks, and all of them. It's otherwise, it's happening quite naturally, and because victims are businessmen, And I fully agree with you because I have to deal with such cases every day. And first of all, I work with the victims. But look, it's not because of Article 159, the more universal norm. It's asset or merit rather than detriment. And so long as you change the norm and you see that fraud in terms of banking activity, nothing will change because nothing of the sort. You're a professional, it will not be that way. If you have to prove that there is sometimes have illegal negotiations, you can have it. And if you read what the Supreme Court has resolved and issued as a directive, you would be amazed. And I would look at this some other problem. Do you know who? That is how the judge their mind in Leningrad region. They changed most of the judges, but if you have kind of a lawyer certificate, it's like a black spot, if you know what I mean. Now, suppose we will give somebody a chance to respond to what you have said. In picking up on that issue, that there is a law and a killer comes. If there is no law, the killer comes. And I want to apologize before my English colleague. There's a joke when a British lawyer, and he is happy and says to his father, the case that you trusted to me, you know, I finished that case, we won it. And he said, you're crazy or what? Because we have been fed by this case for so many years. Your granddad was sort of getting money on that. And otherwise, talking about liberalization, the fact that most of the lower levels were abolished, not from 0, but from 2 months. That's the minimal term, if you want to be fair about that and square about that. But there were lots of examples when judges had to refer to the fact that the law permitted them to do something. In time, they could not go below the lower threshold, and if they had done it, they could have various sanctions from the upper authorities, higher authorities. So this is one of the arguments why they eventually decided to remove the lower threshold, which was not aimed at immunization, because they did not raise, but they lowered. So I agree with you in terms of points. If you looked at it mathematically or arithmetically, probably it would be easier to exclude corruption. But we live in this country, and the reality is such that wherever the social danger is high enough, probably punishment should be lower. And if previously the imprisonment term was 7 years, now 3.5 years, and the upper level is the Article 174, legalization was reduced, and the threshold was also modified. It's something as regards Article 159. I'm very much against the bill that was brought to the Supreme Court. The disposition is not touched on, and we only kind of expand. People who do not fall in that category will fall in that category, 159 category. It will worsen the situation rather than improve it. We can only improve the situation if the disposition of the Article 159 is changed in such a manner as, if I had a simple answer, an easy answer, I would have changed it on the fifth communication, but they have several communications in Europe and whatever.
They do not have this universal norm. Well, I cannot give you an exhaustive answer, so let's stop at this answer. Let's move on. Dear colleagues, you're welcome. Errol Kasyanov, lawyer from St. Petersburg. I think that we shouldn't focus on Article 159. As a person who came across representatives of enforcement bodies, I see the problem in the low level of skills. For instance, when we are dealing with illegal loan or forcing somebody into bankruptcy, they say, no, we don't know what to do with it. We know Article 159, and that's how we're working. And while every enforcement officer, in view of its low economic education, lack of some basic economic knowledge, who never read a standard business plan with a section when wherein a businessman set up a business to extract profit, and the indictment always says that the group of businessmen worked under collusion for the purpose of getting illegal profit. Well, they have no idea that it's legal, that's good for the state, it's good for the public. They know nothing about it. And therefore, the two major problems that we have is corruption from starting from operatives, investigators, and up to the high-level officers, including courts. And now the only thing that really works in these cases, in case of lack of law, is the public coverage, the broad coverage, because in the subconsciousness, a person who is involved in corruption, working on orders, so that if it is covered publicly at some period of time, sooner or later it can surface when there are mechanisms allowing them to bear punishment. Therefore, the problem is very broad, and when you come across them in the practice, you get discouraged because you don't know where to start. And very grateful to Jan for being active. I follow your presentations, publications, and I think it's the right way. Thank you very much. Esteemed colleagues, who've been working for 3 hours, I suggest that we can allow one question, and we're going to sum up. Any questions? Minister of Justice, it's my judgment. I do support liberalization of criminal legislation. And let me give you an example. In Kaliningrad Oblast, starting from liberalization time, people under prosecution were released from prisons. Businessmen were released from remand prisons. And believe me, out of 1,999 did not escape. They cannot influence the investigation, which was claimed before this. There was a system of forcing out confessions from the people, and this was done through putting them into a remand prison. If a businessman, if he's put into a criminal environment, when he is put into a cell with more than 8 to 10 people, and he understands that they can do something with him unless he confesses, and if he confesses, he will be immediately released. So they made this deal. So in this case, the investigating bodies got whatever they were after, property or whatever. When the liberalization of the system Natalia Satikhina said that there is another side of the medal. Well, it's bad this way, either way, but it used to be worse before. It was worse for businessmen. And now businessmen started to make use of their rights, and even they abuse their rights, but still it is better for businesses. People could breathe now. They believe that they cannot be put into remand prison, and a criminal case started that could be started before them. Oh, we should put everything in order. Probably we should tighten criminal punishment, but it should not be done straightforwardly. It should be responsibility of the judge If the judge made 5 sentences which were set aside, she either should lose her post or should be made liable for it. So she can make 100 sentences without being liable for wrong sentences. And the same should be true about investigators, and they should be responsibility of the state. If the person spent an illegal sentence, so the government should pay, the state should pay millions, and measures should be taken against the official, the investigator who committed this illegal action. Well, certainly, it's no use in hiring an old woman who said, I worked 20 years and I know that this is true. Yes, thank you very much. Let's go over to summing up. When the Code of Criminal Procedures was amended to prevent the arrest of businessmen before court, at the same time they changed the federal law on the entry and going out of the Russian Federation, but they banned people from leaving the country if he is under investigation. So there is one database, he is entered into this database and he can leave country. If he, well, there's an enforcement system who takes care of it, so and he might be punished for it. So, well, it's not serious claiming that the person can escape. Very few people escaped. People are prepared to stand for their rights, but why should they come to the court handcuffed? One should come wearing a white shirt with his defense lawyer to defend his rights. The person might be acquitted or convicted, or probably he will not be sentenced to spending time in prison, whereas his company is already seized. The experts who would like to sum up, I'll give them a couple of minutes. And that's sum it up. Do you want to say anything? I should be.
Faces a challenge when it comes to considering how to draft legislation for a fraud. The Law Commission, which took 16 different categories of offense in 2002, struggled for a long time to recognize that capitalism involves people working together to make money, and trying to say how they can do that without committing a crime was a challenge within Great Britain, where we have a long tradition of trying to make money. The other thing that we have found to be very successful is for the actual victims of crime to be in charge of the recovery of their losses through the civil courts. The civil courts know how to deal with money. The criminal courts know how to deal with prison.
Спасибо большое.
Thank you very much, Mr. Firestone. Very briefly, for 6 years I've been in Russia, and I stood one thing, that the problem of criminal policy in Russia are unique. And they require unique solutions. And the solutions you're looking at, for instance, forbidding to arrest the businessman, the possibility to pay a penalty, 5-fold penalty, instead of spending time in jail. Probably they violate the norms, the major principle of the criminal law. But if they resolve specific problems, it's more important than observing the norms. Therefore, I support you in this creative process. Thank you, Thomas. I'll tell you briefly that it does not violate the rules, the norms of the legal law. The question is to much extent it allows to protect the laws of the rights of businessmen. Let me remind you, colleagues, that we have to take social institutes because the criminal justice does not work. Well, there's nothing better than court and professional legal aid. There's nothing better and safer in the world. We also have the problems of safety in regions. So we should give the victims with procedural possibilities to realize their right for protecting themselves. Last year it was rightfully said by our British colleagues about the situation that happened in Scotland Yard. Well, the Harvard students, the Harvard graduates invented some criminal schemes, and Russia cannot investigate such cases. There should be professional lawyers who should do this. And our objective is to try help the business community. If the business community turn to the business professional lawyers to deal with the stability of court decisions, the transparency of court decisions with enforcement bodies operation. Most of the sentences are turned into conviction, but many of them do not make it to court. So, dear colleagues, I have a great request. Let's focus on the fact that the developed democracy already arrived at its independent court and transparent procedures, rather than changing the criminal code itself. Well, the amendments are necessary, but we should be very careful about it because it's a very powerful remedy. We should look after regulatory mechanisms. Konstantin Borисovich. Fair. You've been very patient. You were itching on your table. You wanted to say something. My colleague started as my opponent.
She began as my opponent, but she concluded the same words that I started. And I would like, in summary, to tell you that I suggest that we go back to the criminal policy and to kind of divide it into strategic and tactical parts and the essence of the changes that are occurring in this country of contemporary policy are very much in the concept of an armored vehicle, that is to create an armored vehicle, and the prosecutor would have a kind of a another piece of protection that is, it will not lead to the improvement of the economic situation. But you know, if you look at it tactically, you have to weigh up to kind of terms the harm that criminals, which are at large, they can do, and the law enforcement officers, which have to wear the dog mugs, kind of, you know, they cannot stop them. So basically, they probably. All this concept of the armored car vehicle, you know, it's probably it works, and it has to do with what he's trying to say is that, you know, criminals feel that they are an armored vehicle, whereas the sort of law enforcement officers don't have any facility to challenge them. So this concept has to be based on the harm that can be caused by the law enforcement system. Strategically, I support my colleague and supported her. Thank you, Konstantin. It's difficult not to agree with you because now praise Dorota Lynch, whatever. Thank you for not just coming. You spent 3 hours of your time with us, and can you tell us what you can have and say in conclusion, please?
Thank you. I'd like to say that one of the benefits for me on these panels is I learn much more than I actually am able to say. So for me, it's been a wonderful learning experience. I think you're struggling with a great many concepts all at one time, and I commend you for not backing away from the challenge. A number of different solutions have been offered here. I think you may find that you end up using parts of several of them because there is no one answer for the question of how to handle economic crime and also how to handle corruption. You have a large country, you have a diverse country, you will need diverse solutions for that. It certainly is something that we have found as well. I particularly commend my colleagues on the panel from Great Britain who focused on the importance of the civil law remedies for these. One of the concerns that we always have in the U.S. before we prosecute for an economic crime, either a corporation or an individual, is whether or not we are being pushed in that direction by someone who is an economic rival of that person, and so that's always something to consider. And there are many times when we decline to exercise criminal jurisdiction because, in fact, the civil courts can handle the matter better. But I think what that speaks for is the need to have many, many options to address this solution. And again, I commend you for working on this difficult issue. And I'm looking forward to coming back next year to seeing how these issues have been resolved and how they have been progressed.
Спасибо большое, госпожа Лоретта Линч. Спасибо вам большое.
Thank you very much for your participation. We appreciate that, and your kind words too, and you're a very nice lady too. Dr. Guy, thank you very much for coming here to us, and we really thank you.
I just want to say one thing, because I know that you're sitting for more than 3 hours. I enjoyed, and I've learned as well, but mostly I've learned about the freedom of speech and freedom of expression here in Russia. I think that this is another achievement of democracy, and I think you should be proud of it. Thank you.
Спасибо большое.
I want to thank you very much. You really helped us a lot, and hope that next time you'll also come to us, and we'll have a follow-up on that. I'll only say a couple of words in conclusion, because I think one of the results of our discussions is the fact that the people are looking forward to the courts and the lawyers to solve the issues with regard to the return of their properties which have been confiscated, and the protection of their interests, and that is to collect evidence and proofs and to undertake various actions. As soon as you do it, people will start come to the corrupt policemen of their corrupt statements. That's it. That's how you have to solve it. And now, Simon, thank you very much. Although you came to us a bit later, but I thank you very much for your involvement and participation.
Yes, thank you. I came later because I was giving another lecture, which was put back by an hour and a half. I think conceptually, what you have in front of you isn't actually going to be that difficult. It's the implementation that will be difficult. I think you should do 4 things. You should firstly get your laws clear and fair and impose them consistently and reliably. People should know where they stand. Secondly, allow businessmen to grow your country by taking responsible risks with capital. Thirdly, stop clear abuses and irresponsible use of capital. And fourthly, remember to use other remedies as a package for enforcement and balance of all people's rights. You do not always have to engage with the criminal law when you have other tools you can and should use. I would like to commend everybody here for participation in this. I've thoroughly enjoyed it, and thank you very much for the invitation.
Спасибо большое. Спасибо большое всем участникам сегодняшнего.
I want to thank all the participants of this round table. I would also like to say that in this country, from my perspective, there is a great potential that will help us overcome all the obstacles, and this international forum is another proof that we are prepared to counsel with each other and with people from other countries. And the Minister of Justice of our Federation, Mr. Konovalov, there was an appeal to the participants of the forum that it's not only important for us to get together once in a year and to discuss various problems, but also to work online between the forums in the interim period. So my suggestion is that all the participants who are addressing these issues in this round table, suppose we start working on a permanent basis, and when we come to your countries, we can also address similar problems, so that we would not have this 1 year sort of gap between our meetings. And as far as the Russian Federation is concerned, So, in this context, whatever proposals we can develop so that they could be implemented by the authorized ministries. And I spoke that we have lots of instructions to various. We want to create a standing kind of venue where various representatives would be there, and I think that we actually can come with such a proposal that we have a sort of permanent operating entity. And as I promised from the onset, we will make a joint picture now. You'll see the picture. Please do not stand up, sit as you are, and the rest will come and surround you, and we'll make a collective picture from that angle. It will be for our memory, and several years later, we will we will sum up our results. So stay where you are.
Пошлем, кто оставит визитки.